Hey guys, another Monday, another flurry of court filings in the Delphi case. This one piqued my interest. This is from prosecuting attorney Nikki Slicky McClelland, who's respectfully requesting the court to enter an order requiring the defendant or his counsels to refrain from mentioning anything that might possibly create reasonable doubt, or anything that might upset him, or anything that might show his case to be very thin. So I'm going to read this and I'm going to reword it based on what Nikki probably actually meant.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Got to refrain from mentioning in the presence of the jury, so during voir dire, opening arguments, presentation of evidence, or closing arguments, or any time, any and all references to the following, either directly or indirectly. So define indirectly is basically anything that Nikki doesn't like. Right. Any comments about counsel for the state that constitutes a personal attack on the attorney for the state, or comments on the role of the state's attorney. So was Nikki expecting to have personal attacks against him? Is that because he's got a guilty conscience that he's actually a really rubbish prosecutor? I don't know. Any comment which constitutes the personal opinion of defence counsel about any evidence, witness, outcome, or penalty. For instance, defence counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses. So, all right, no personal opinion. I can accept that. Any innuendo or inference that is not supported by admissible evidence. It's almost like he thinks that the defence aren't very professional or something. Any attempt to indoctrinate the jury. Who would hear? By exposing the jury to substantive issues on the case. Again, are we claiming that they are so unprofessional that... I can't. It gets better. It gets a lot better. Any attempt during voir dire to have the jury prejudge the credibility of a witness. Any hypothetical questions that include facts that are not in the evidence, or questions that are not helpful in violation of Rule 705. Well, I've not looked up Rule 705, but basically anything that's not helpful to the state's argument. This is the biggie. This is Nikki's insecurity shining through here. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. So basically anything that might create reasonable doubt or might constitute a third-party defence. Like saying someone else did it, not Richard Allen. Before any such evidence may be permitted, the defence must show some connection between the third party and the crime. South Carolina reference. Why is that relevant? Anyhow. Further, it must be a direct connection based on admissible evidence and not founded in hearsay. Objection, hearsay. Yeah, we know that hearsay isn't evidence. We know that. Speculation, rumours, conjecture, or theory. The state requests such order in limine to include, but not be limited to, the following: Odinism, cult or ritualistic killing, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Kegan Kline, Jerry Klein, who's Tony Klein, and Ron Logan. The defence aren't saying that the Kleins or Ron Logan have got anything to do with the theory of the case, with the evidence that they've accrued. These guys, on the other hand, these Odinists, very much so. Any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues, or has the potential to mislead the jury. Okay. So, basically, again, like I said, anything that might create reasonable doubt in the jury's minds. So it's like saying they can listen to the state's evidence against Richard Allen, however weak that might be, but they can't be given any alternative facts based on other investigations that were conducted that might contain stronger leads if they'd been adequately followed up by law enforcement. So Rule 401, burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. So prejudicial against the state's weak evidence that Richard Allen did it. All right. Okay. Evidence may be excluded if it confuses the issues, if it might confuse the jury, if it might think that that evidence is weak and that there's other evidence that's stronger. Well, we can't have that, can we? No. Okay. Any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings of any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. So they can't even mention geofencing. They can't even mention geofencing because that's going to confuse the jury. Burden is on the opponent to show why it's relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. And who decides what outweighs what? Well, of course, that's Francis, isn't it? Evidence may be excluded if it confuses the issues. So geofencing is going to confuse the issues. Well, that leads me to believe that the theory of Odinism, the third-party defence there, along with the geofencing, is actually maybe a lot stronger. Maybe a lot stronger than the evidence that the state is going to bring against Richard Allen. Any reference to any prior bad acts or acts of any witness that plans to testify that is not relevant to what the defendant is on trial for. That is not an act that is exception to IRE 404B, and that is not both relevant under IRE 401 and tend to negate the guilt of the defendant. So what the state is bringing up against Richard Allen, we can't have that either. Any reference to how the files were labelled that were handed over to the defence. So you're admitting that your labels were bad. All right, cool. As part of the information and discovery provided to Defence Counsel by the state, that is not relevant or that would tend to cause confusion of the issues or would embarrass Slicky Nicky and his office or has potential to mislead the jury, blah, blah, blah. He's even very upset about his labelling. He's embarrassed about his labelling. All right. Now, this one is interesting. Any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German. Hold on a minute. You've mentioned the victims' names in a court filing. Wasn't that constituting of gross negligence? Wasn't that something you said, Slicky? Isn't it? All right. That is not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on, blah, blah, blah. So what's this PowerPoint? What was in this PowerPoint that they don't want to come out? Wherefore, the State of Indiana, by prosecuting attorney Nicholas C. McClelland, respectfully requests that this court grant the following relief. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever to anything that might show the state's evidence against Richard Allen as being a complete farce and very weak, and to further order said persons to make no reference to the facts that might show that the state's evidence is really weak and that Richard Allen isn't guilty, or at least may give the jury enough reasonable doubt to acquit him. What are the bets that Francis will say, granted without hearing?